Thank you so much, everyone. It's a real pleasure to be here, and thank you so much for the invite. It's really wonderful to actually be able to present this very initial research. So I hope everyone can hear me at home as much as in here in the room. If not, please just wave your hands, and I'll because you're on different sides of me, so I'll try to say things to this side and things to this side. So I thought I wasn't sure if anyone was going to introduce me, so I do have a slide on introducing myself. Obviously, this has already been said. Maybe I can just add that because it's what I'm actually going to be presenting. I'm a fellow of the Scottish Parliament. That means that actually I work for the Scottish Parliament in terms of producing policy papers, in terms of policy advice, in terms of specifically Justice and Home Affairs, Police and Judicial Cooperation. And so a lot of the data that I have here today actually stems from my work in the context of the Scottish Parliament. I'm also secretary of the British International Studies Association. That's the association, the professional association that is responsible for international relations in the UK. I'm sure it must be the sister association of the Belgian International Relations Association. I'm trying to guess.
We don't have one. We have the Belgian Association of Political Science.
And then international relations.
Political community to have divide between international relations and political science.
We've divided ours, but yes, everyone gets along essentially. And in terms of my research interests, that's already been mentioned. I work on Justice and Home Affairs governance, which in UK, because people don't really know what Justice and Home Affairs is in UK, we call it internal security. So that's actually, people understand that we're not talking about defense. And I mainly work on, traditionally I've worked on organized crime, and I started working on cybercrime. From there, I jumped onto cybersecurity as well, which obviously goes beyond Justice and Home Affairs. And I do a little bit of migration and asylum, not at a European level, but actually on the UK, in the UK context alone, specifically. And obviously, I'm very interested in EU external relations, and I specialize on UK-EU relations, as it's going to become very clear from my presentation. So I was very keen to present in the context of the seminar series here. And that was until I was told what the topic of the seminar series was. When I was told that actually it was about the silencing of voices, suddenly I panicked for a little while. And then I thought to myself, okay, how do I fit into here? First, kind of my first flippant comment was to think to myself, well, the only person that feels kind of silenced in the context of what I was working on at the time, Brexit and Police and Judicial Cooperation, is essentially, like me. I feel very silenced as somebody who actually did not get a vote in the referendum and would have preferred to stay. And obviously, Remain ideas and Remain opinions became quite silenced and very repressed in UK for a long time. So I thought, obviously, I'm not going to make a presentation about me, ridiculous, obviously not. But that really started to actually get the ball rolling in terms of thinking, is that who is actually silenced within the context of the research that I'm doing? And that led me to think that actually there is a group of people that actually do appear, although they don't acknowledge it as such, they're not allowed to acknowledge it as such, do actually appear to be silenced. And those are practitioners. Let me give you a bit of the context here. So, and that kind of leads me to actually then explain to you what the article is going to be about. So, when the UK took the decision to actually exit in 2014 a very large number of police cooperation measures, police and judicial cooperation measures, it did so, but with the consensus of practitioners who actually were very clear that there are so many measures that are so important for the UK to keep that actually any decision to leave would need to immediately take into account the need to actually go back into specific measures. And so what we see very much is that actually in 2014, the government listened to practitioners. It had a consultation that lasted for 6 months. It actually asked practitioners what they thought. Practitioners were very forthcoming. They submitted lots of different evidence, lots of different statements, very detailed things. It was a very long analysis of that decision, and the government decided to exit those measures, but then immediately retain the most important ones. I will explain all this in greater detail. So in the first instance, in the first historical instance, we see practitioners being listened to and actually being considered quite highly. That is very, very different, however, when in the second historical instance, when the UK decided to leave the EU. There, we have a completely different scenario where, although the measures in terms of police and judicial cooperation are very similar, and the arguments are very similar, which the practitioners tried to make, UK actually decided to completely ignore practitioners, did not run a consultation, bypassed parliaments, and actually hence silenced in practice practitioners. So that is essentially what I'm going to be talking about. So let me start with my departure point, which is the existing literature. The existing literature is essentially the why, we find ourselves in the Brexit literature. Brexit literature has boomed over the past couple of years, but boomed, seriously boomed. It has become a field of study. So, since, it's less than 10 years, we have an entire field of studies now called Brexit studies. And they are conferences on Brexit studies. There are panels. There's, it's always present. And there's a number of strands within this literature. A lot of it, obviously, understandably, focuses on UK foreign policy. There's also the role of domestic politics and how that has influenced the decision or not to Brexit. There's also the UK search for different forms of narratives in terms of UK foreign policy. Once it has Brexited, what kind of country does the UK want to be? What kind of vision does it have for itself in terms of an international actor? And so I just need to move this little window, which is in front of my, there you go. And it also, there's a part of the literature that talks about, so if we, given that the UK is no longer able to actually continue its foreign policy the same way in relation to the EU, then what are the alternatives? What are the international fora out there that the UK can use to actually exercise its influence in the world? And then there's, within that, ways of thinking, there's also another stream of this literature focusing on bilateralism, which, Agathe knows very well because we wrote a piece, this year, really, it came out about 2 months ago, which talks about the fact that the UK has tried to compensate its loss of its connection to the EU with developing a number of bilateral relations with member states. So trying to compensate UK-EU relations with bilateral relations. Within this literature, there's a very limited literature on internal security specifically, on justice and home affairs, and specifically on police and judicial cooperation. Most of it is really about the impact of Brexit on police and judicial cooperation. I'm speaking as myself because, one of them is a book that I did in 2019, edited in 2019. They're essentially pieces, articles, and books that say, well, given that we're going to use access to the Schengen Information System, for instance, then this is possibly the consequences for the police officers and for crime. So it's not academically very conceptualized, very theorized, and very advanced. There's an attempt to start to actually conceptualize some of this literature, which, again, an article that we wrote, to be honest, she's paying me for lunch. I'm here to advertise her work. So an article that we wrote 2 years ago, which is what has Brexit meant for different justice and home affairs policies, where the UK actually, this area of literature basically looks at what does Brexit mean in practice, and we realize that actually Brexit means completely different things depending on whether we're talking about migration, police and judicial cooperation, or cybercrime, cybersecurity. So the impact on the ground has been felt completely different, and the impact has been different. If we look at all this entire literature put together, if we think that actually our interest here is on practitioners, then there's even less on practitioners. In practice, there's only 2 pieces so far in the entirety of the literature that has been written on practitioners. One of them is a book that is currently with Hart Publishing, is currently being in a process of being printed, and Agathe also has a chapter in it on the environmental crime. So this book actually looks at the implementation of the trade and cooperation agreements. So it doesn't look at the impact of Brexit, but rather at the impact of the agreement itself on the ground and how practitioners have implemented it or experienced it. And then this other article below by Shawakar just basically says, it's a criminology article and actually talks about how practitioners have adapted to the reality on the ground. So in practice, there isn't anything out there that talks about the relationship between practitioners and the political level, and talks about the lack or the capacity of practitioners to influence, with their knowledge, the decisions that decision makers make. And I thought, well, this is clearly a very big gap in literature. And, well, somebody has to try and fill it. So there we go. This is my attempt to try and fill it. How is it that I try to actually answer this question? So I'm going to pick up again on something that I started at the beginning. So I'm going to try and give you the main arguments. So that kind of rejigs a bit what I've just said before. The main argument of the article is that actually it compares two different historical periods. The first one being 2012-2014, during the decision to actually leave a very large number of measures in the context of the Lisbon Treaty. And the second one is the 2016-2020 period of the Brexit negotiations. And it compares the capacity in both. It compares the capacity of practitioners to actually voice their concerns, discuss what they think is going to happen if we give up certain measures, police and judicial cooperation measures, and it looks at whether the government has actually listened to them procedurally, but also in terms of output, in terms of outcome. So it's basically what it mentions specifically is that actually the difference between the two historical periods is a process of politicization. In the first period, politicization is absent. In the second period, the politicization of police and judicial cooperation is very prevalent and very clear. And that leads to a clear silencing of practitioners, where you basically see that political arguments and political vision trumps operational security priorities. And so post-Brexit, essentially, practitioners find themselves in a position of reduced cooperation, reduced data exchange, and reduced dialogue with their EU counterparts. So silencing is understood in two ways in this article. The first one is a type of procedure silencing, in the sense that actually it's not that they weren't given the possibility to speak. They were always given the possibility to speak, but rather that actually their voices become much less relevant, less influential. They are ignored. And the second type of silencing is a physical silencing, in the sense that actually they have, in practice, lost the possibility of speaking to their counterparts. Their communication channels were effectively cut, or actually dramatically reduced with their counterparts in terms of European, Belgian police forces, for instance. So how do I propose to answer this question from a theoretical framework perspective? So I've done a bit of work on something called communities of practice, and on the concept of politicization. So what I try to actually argue is that police and judicial cooperation practitioners form a community of practice that has evolved over the years in a form of socialization with their European counterparts. They have learned from them, they have cooperated with them, they actively work alongside them for many, many years. And so I take the Lav and Wenger definition of communities of practice, who actually introduced the concept itself. And for me, it's a community, it's a knowledge-based community of individuals who actually share a common goal, a shared endeavor, a sense of joint venture, who learn together through cooperation, who actually learn through shared practice, and more importantly, because of the way they have evolved, they have developed a very clear sense, very clear capacity to resist external ideas or decisions that come from the outside. Alongside that, I'm thinking of using the concept of politicization that I take from Hug and Marx. And so for them, the concept of politicization should not be understood just as a given or inevitable process, but it's very much a consequence of the deliberate political choice, right? That political actors have used to actually shape the context and legal and political rules of a specific arena where a debate is taking place. And so politicization in practice shifts a specific debate from an elite focus or restrict focus group to a much wider public. And actually it results in polarization, it results in contestation. And so then actually it results in changes, very dramatic changes in policy. And essentially, as you can imagine, the main argument that I make is that I'm interested in understanding what is needed to silence communities of practice. If we think about the context in which communities of practice operate, the political context, the rhetorical context, what is necessary to change there so that actually it affects communities of practice to the point where they become dysfunctional? The method that I propose to use is simply a discourse analysis of documents that the practitioners submitted either to the government, to the parliament, or even interviews that they gave to the media, and then semi-structured interviews with practitioners. I'm aiming for about 50, which is a very large number for this field. I've already conducted about 40 of them, thanks to my work with the parliament. Now, in terms of challenges that I'm actually experiencing at the moment, this is where I could really, do with your help. Is silencing the right concept, or am I just trying to fit into the seminar series? I really like the idea of silencing. I really want to use it, but is it actually the right one here? If it is, should I actually find a way of conceptualizing and integrating it into the theoretical framework in addition to the COP and the politicization? Another question that I've struggled with is who counts as a practitioner? Admittedly, I've only interviewed people who work as police officers and as judicial officers in courts in international units. So I've actually worked with the people who on the ground kind of arrest people, extradite people, etc. There's another whole category of people out there who are also practitioners that I have completely excluded, which are policymakers. Are policymakers who actually work in the UK mission to the EU, for instance, or in the Home Office or the FCDO. Should they be included in a piece of work like this? Or will just muddle everything and it will be too difficult? And finally, is the paper actually convincing? Am I making a convincing argument? Which is always an important thing, really. So the structure of my talk is, I'm going to start by giving a bit of a context of UK-EU police and judicial cooperation relation, because I understand that not everyone here is a specialist in police and judicial cooperation. So I just give a very brief summary of this area. Then I go into my first historical phase, the 2014 mass opt-out from pre-Lisbon police and judicial cooperation measures, where I talk about the absence of politicization and then the influence that this COP has had. And then I move on to the final historical phase, the Brexit negotiation and the impact that it's had on police and judicial cooperation, where I go through the same thing. I talk about the politicization and then the impact that politicization has had on the COP. And I hope I will make a convincing argument. I'll just ask for a favor, Agathe, if you see me talk, like I usually do, which is too much. You see me talk beyond, let's say, I don't know what the time is. I don't have it actually.
Right now, it's 5 to 1.
5 to 1.
Yeah.
So when do you want to?
So it means that you started 20 minutes ago.
50 minutes ago.
And I will be the only discussant. So, and I can make it short if you want to be.
No. It's fine. You interrupt me when you interrupt me. So when do we have me to start?
Let's say you have 25 minutes. It's fine.
Okay. Yes. It's fine. And 5 minutes before that, you kind of make me a signal, and I kind of speed up.
Okay. Okay.
Right. So just in terms of very brief history of police and judicial cooperation, because obviously, some of you might not be from this area. So police and judicial cooperation in the EU, police and judicial cooperation in Europe did not emerge as part of EU integration, EU cooperation. If we go back to the 70s, what we see is an interest of specific member states of actually wanting to discuss issues of police and judicial cooperation because they were observing things on the ground related to organized crime or to terrorism or even to migration, that they felt an urge to discuss with their counterparts, even if it did not fit within European integration structures. So in a way, they started to meet outside of the official structures to actually discuss some of these concerns that they had. The cooperation ended up being formalized in 1993 into the EU structure, thanks to the Maastricht Treaty in 1993, because obviously there was the argument that actually the security dimension was becoming so prevalent, so concerning, that it was important for the EU to try and integrate these informal discussions into the EU structure. This cooperation started to expand, which started very much on an intergovernmental level, started to expand very rapidly. And so over the past 30 years, what we have is going from a very ad hoc cooperation to one of the most structured and one of the biggest policy areas of the EU, which is the area of freedom, security, and justice. So that has evolved very quickly by mutual recognition, but also through the creation of many different instruments, such as agencies like Europol, Eurojust, but also specific instruments such as databases like the Schengen Information System, which is the largest database of criminal data of the entirety of the world in practice, and other instruments like the European Arrest Warrant, which is a surrender extradition instrument. So the idea was to create the largest area of freedom, security, and justice in the world, to be able to provide security, stability, and freedom to its citizens and to the residents of Europe, of the EU. And so today, if we look at the area of freedom, security, and justice, we see that actually it is probably the most important, most dynamic policy area that the EU actually has, even including the common market. And it covers the areas of fight against terrorism, fight against organized crime, cybercrime, but also the area of migration, asylum, and external border protection. If we think about the role of the UK within the area of freedom, security, and justice, what we notice is that UK was always had a foot in and a foot out. Always had a bit of a special status. The UK was always very much in favor of having a lot of operational cooperation in justice and home affairs, but at the same time, it felt quite reluctant, quite uncomfortable with the idea of giving up sovereignty in an area that was so important, like internal security. And so when it saw the European integration actually make a very quick evolution in this area, the UK actually decided to negotiate an opt-in and opt-out system. This was started to be introduced in the Amsterdam Treaty in 1999. And so what the UK had until Brexit was a really comfortable system. It was what we call an à la carte system, where the UK, presented with different instruments in the area of justice and home affairs, could decide whether he wanted this one or not that one, opt into this one, but opt out from that one. It was really, really comfortable. And in practice, the UK's participation in the area of freedom, security, and justice really matched its UK national interests and priorities. So if we think about police cooperation, the UK was part of Europol. The UK was part of PUM, which is a database of DNA, license plates, and fingerprints. It was part of the passenger name record. It was part of the Schengen Information System. It was able to take part in joint investigation teams. It was very, very present. Same thing for judicial cooperation. It was part of the European Arrest Warrants, so the extradition instruments. It was part of Eurojust. It was part of ECRIS, which is a database of criminal records. And it even took part in border asylum and migration systems, like the Dublin system or the Eurodac, which is a database for asylum fingerprints. So the UK was, despite having a foot in and a foot out, it was incredibly present in this field. And in fact, it was actually, most countries would recognize the expertise of the UK and value the expertise of the UK, and it was considered to be a leader in a number of areas, such as mutual recognition and intelligence-led policing. So that's